Thailand's May 2026 termination of the 2001 Maritime MOU, often called MOU 44, and Cambodia's subsequent initiation of compulsory conciliation under UNXC Annex 5 on June 2, 2026. The map scale comments 1 to 50,000 versus older 1 to 200,000 primarily concern land boundary issues, not the Maritime MOU, though they reflect broader tensions. The 2001 MOU 44, from Buddhist calendar year 2544, created a bilateral framework for negotiating maritime boundary delimitation and possible joint hydrocarbon development in the overlapping claims area of the Gulf of Thailand, roughly 26,000 square kilometers, with significant oil and gas potential, estimated in the hundreds of billions of dollars. After 25 years, progress was minimal. Few formal meetings, no delimitation, no joint development, due to political instability, nationalism, and differing interpretations. In May 2026, Thailand's cabinet under Prime Minister Anutin Charnvirakul unilaterally terminated the MOU. Thai reasons included lack of results, the agreement having become a source of suspicion rather than cooperation, and a desire for a fresh start. Cambodia expressed regret, stating the MOU had been the only bilateral framework and that its termination left no option but to pursue resolution under the United Nations Convention on the Law of the Sea, UNCLOS. On June 2, 2026, Cambodia formally notified Thailand and the UN Secretary-General of its initiation of compulsory conciliation under UNCLOS Annex 5. Both countries have declarations under UNCLOS Article 298 excluding maritime boundary delimitation disputes from compulsory binding settlement, ICJ, ITLOS, or arbitration. However, Annex 5 compulsory conciliation remains available when negotiations have stalled. The resulting commission issues non-binding recommendations to help parties reach agreement. Thailand has indicated it will operate under UNCLOS rules going forward and has commented that both sides are now under the same set of rules. The 1 to 50,000 scale map comments by PM Anutin refer mainly to land border negotiations. Thailand insists on its more detailed modern surveys. It has stated that older 1 to 200,000 French colonial-era maps from the 1904-1907 treaty period, often relied upon by Cambodia in certain sectors, no longer exist for Thai purposes. These are technical and historical disputes over accuracy, watershed lines, and treaty interpretation, not something drawn by a Thai king in the simplistic way described. The 1962 ICJ Temple of Preah Vihear case referenced a 1 to 200,000 map, but implementation and adjacent areas remain sensitive. Why did Cambodia initiate UNCLOS compulsory conciliation after Thailand terminated MOU 44? We are examining the diplomatic and legal logic behind Cambodia's June 2026 move and Thailand's May 2026 termination, plus related map positions. Both sides claim commitment to peaceful resolution under international law. The conciliation process is non-binding. Success depends on good faith participation. Cambodian representative. Thailand's unilateral termination of the 2001 MOU removed the only agreed bilateral channel for addressing the overlapping maritime claims. After 25 years of stagnation, ending that framework without a replacement or consultation left Cambodia with no practical bilateral path forward. Invoking compulsory conciliation under UNCLOS Annex 5 is a lawful, peaceful next step. It brings neutral experts to examine the dispute and issue recommendations that can break the deadlock. The stakes are enormous, untapped resources worth hundreds of billions. Cambodia is not escalating. It is responding to Thailand's removal of the prior mechanism while reaffirming commitment to international law and good faith negotiation. Thai representative. The 2001 MOU had failed its core purpose after a quarter century. With only a handful of meetings and zero delimitation or joint development achieved, it had become an obstacle that generated suspicion and blocked practical progress. Sovereign states routinely review and end political arrangements. MOUs are not binding treaties that no longer serve national interests, especially when domestic realities, including recent land border tensions, demand a reset. Thailand remains willing to negotiate maritime issues under UNNKOSS principles. Cambodia's turn to compulsory conciliation is understandable procedurally, but unnecessary if both sides engage directly. The process is non-binding and Thailand can participate while preferring bilateral solutions. On maps for land issues, Thailand prioritizes accurate, modern 1 to 50,000 scale surveys that better reflect current ground realities over coarser historical colonial maps. Insisting on technically superior data is a legitimate sovereignty position, not rejection of all history. Cambodian representative, terminating the MOU after 25 years of its own making is not a neutral reset. It is a unilateral act that shifts the burden onto the other party and forces internationalization. Cambodia had consistently sought to work within the bilateral framework. Conciliation provides structure and expert input precisely because pure bilateral talks had stalled. Resources remain undeveloped for both sides. A facilitated process can lead to creative solutions like joint development zones seen elsewhere in Southeast Asia. Stalemate under the old MOU benefited no one. Ending it clears the way for new, realistic negotiations without the baggage of an ineffective agreement. Thailand has publicly stated both countries now operate under the same UN close rules. On the map question, land borders. Modern 1 to 50,000 mapping by Thai technical authorities offers greater precision than 1 to 200,000 colonial products, whose lines sometimes do not align with actual watersheds or agreed markers. Cambodia's reliance on older maps in some sectors does not obligate Thailand to treat them as definitive everywhere when better data exists. Cambodia views the MOU termination as removing the agreed process, justifying recourse to UN-CLUS compulsory conciliation as a good faith, lawful response. Thailand views the MOU as a failed instrument whose end allows fresh talks under UN-CLUS and insists on technically sound mapping for land issues. The Conciliation Commission, once constituted, Thailand has a short window to appoint conciliators, will produce non-binding recommendations. Whether this leads to renewed bilateral momentum, a joint development arrangement, or further friction depends on political will from both capitals. Nationalism on either side risks prolonging the stalemate. Shared economic interests in stable borders and resource development argue for pragmatic compromise. Maritime delimitation under UN-UNCLOS Articles 74-83 requires equitable solution. Overlapping claims are common and often resolved via negotiation or creative zones rather than winner-take-all. Land and maritime issues are linked in public sentiment but legally distinct. Recent 2025 land border clashes heightened nationalism in Thailand, influencing the MOU decision and map stance. Both countries are ASEAN members with incentives to de-escalate. Serious issues like these deserve clarity, evidence, and respect, not ableist insults.